Well, good evening. I'm recording this obviously prior to our scheduled class time on the 23rd. I chose former Kentucky Family Court Judge Don Gentry. I thought this was a good example because the misconduct was not just one weird incident or one bad comment from the bench. The Kentucky Judicial Conduct Commission found misconduct on 10 out of the 12 counts that the JCC brought, and the Kentucky Supreme Court affirmed her removal from office. The main theme of my report is that this case shows how judicial misconduct can become systemic. This involved campaign pressure, retaliation, court staff, personal relationships, false timesheets, and misuse of judicial authority. So instead of being one isolated lapse in judgment, the findings showed a broader pattern where her personal interests, campaign interests, and judicial power got mixed together. I also think it is useful for applying the Minnesota Code of Judicial Conduct because the facts fit pretty cleanly under Canons 1, 2, 3, and especially Canon number 4. I hope you enjoy my map of the Midwest. It doesn't include Kentucky, but it's right there in that circle. All right, so Gentry was a Kentucky family court judge in Kenton County, which is in northern Kentucky near Cincinnati. Before she became a judge, her background was mainly in family law and related civil practice. Public profiles indicate that she received her Juris Doctorate from Salmon P. Chase College of Law in 2006 and was likely licensed in Kentucky in 06 or 07, although I did not ever find a clean official bar admission date. She was appointed to the family court bench in December 2016, and then she ran for the seat and was elected in 2018. Misconduct proceedings came from that election. In 2020, the Kentucky Judicial Conduct Commission removed her from judicial office, and the Kentucky Supreme Court affirmed that removal. Then separately, the same underlying conduct later led to lawyer discipline before the bar. In 2022, the Kentucky Supreme Court suspended her from the practice of law for 4 years. Interesting to me is that there was obviously a majority opinion from the Supreme Court and then a concurrence that basically said that they agreed with the result. And, obviously, because that's what a concurrence is. And then there was a dissent that basically said they thought that the bar charges should have been dismissed because this was essentially double jeopardy, that she had already been punished for her conduct by the Judicial Conduct Commission, and that this is just repunishing her. They didn't find evidence that led to any charges, and so they didn't feel that there should be anything else to happen with that. The interests of the bar were to make sure that she didn't harm the public again, and they felt like that had already been served by the JCC. So anyway, the basic timeline is law school and practice around 2006, appointed a judge about 10 years later, elected 2 years after that, where she had her misconduct during the election, and in between all of there as well for other misconduct, and then removed in 2020 and suspended from law practice in 2022. All right, so the most direct ethics problem, campaign conduct, is probably the biggest problem. The record described allegations that she used her judicial position to pressure attorneys and guardians ad litem who appeared in her court to support her campaign. That matters because attorneys and guardians ad litem appearing in family court depend on the judge for appointments, scheduling, credibility, and access. Even if the judge does not make an explicit threat, asking for campaign support from people who appear before you creates an obvious power problem. The misconduct included pressure for campaign committee work, monetary support up to and including the maximum that they could possibly donate, campaign activity, and even asking in court whether or not they would put up yard signs. The record also described court staff being used for campaign work during work hours. To me, this is the cleanest Canon 4 issue. Judicial elections are allowed, but a judge cannot turn the courthouse into a campaign operation. And attorneys should not have to wonder whether their clients, their hearing dates, or their professional opportunities are affected by whether or not they support the judge's campaign. All right. The next problem is that the campaign misconduct allegedly bled into the way that she administered her court. The commission found that there was retaliation tied to insufficient campaign support. The allegations included removing an attorney from a guardian ad litem panel and delaying hearings for attorneys who did not support her. That is where this becomes more than inappropriate campaign behavior, because it came into how she ran the court. It became a fairness problem for the people appearing in front of her. There were also findings involving favoritisms related to staff management and false timesheets. She signed off on false timesheets for several employees, including someone whom she had an ongoing romantic relationship with, who she shouldn't have ever hired. It was her minister at her church who she was in a romantic relationship with. So all of this is important because the judge's power is obviously not only the final ruling. A judge also controls the court calendar, appointments, referrals, staff culture, access to the courtroom, and the appearance of fairness. If those things are used to reward friends or punish critics, the court stops looking neutral. This is where I would connect the facts most strongly to Canon number 2, impartiality, competence, diligence, proper supervision of staff, and avoiding favoritism in court appointments or the court administration. You can't be looking to tip your fingers or your foot on the scales of justice. Right, the third bucket of misconduct that she committed was court office misconduct. One of the major findings was that Judge Gentry knowingly approved false or inaccurate timesheets for court employees, and that matters because court staff are public employees and their time is being paid for with public money. A judge approving false time records is not just a bad workplace decision, it is a misuse of the court's administrative authority and potentially a crime. The Kentucky Supreme Court attorney discipline opinion also described favoritism towards certain staff members, including the staff member who she had a romantic relationship, and that creates two separate problems. First, it suggests that court employment decisions were not being made neutrally, and second, it damages confidence that the judges' chambers were being managed professionally. There were also allegations and findings involving inappropriate conduct in chambers and the courthouse, including alcohol use, sexual or personal misconduct, and poor supervision of staff. That actually tied into part of why the one justice on the Supreme Court favored dismissing the Barr complaint, because she had sought out help for her alcoholism and the other issues. And according to everyone who reported back to the court, she had made great strides and had taken a lot of accountability. And since being removed from the bench, there had been no other issues. And there was no issues before this either. This was one time, well, it was an ongoing set of problems, but once she was held accountable for it, she straightened up. I would not spend too much time on the sensational details, because the stronger ethics point is that a judge's chambers are still part of the court. The judge does not get to have a private misconduct zone just because something happens behind closed doors. The bigger point is that the judicial misconduct is not limited to rulings from the bench. A judge also has ethical duties as a supervisor and administrator. Court employees, attorneys, litigants, and the public should be able to trust that the court is being run fairly and professionally. Under the Minnesota Code of Judicial Conduct, I would connect this bucket mainly to Canon 1 and Canon 2. Canon 1 is implicated because this kind of office misconduct undermines public confidence in the integrity of the judiciary, and Canon 2 is implicated because judges have to perform administrative duties competently, diligently, and impartially. That includes supervising staff and not allowing favoritism, personal relationships, or dishonesty to affect court operations. All right, so how do we attach all of this misconduct onto the Minnesota canons. Kentucky rules obviously control the discipline here, but if I were analyzing the same conduct under the Minnesota Code of Judicial Conduct, I would focus on 4. First, Canon 1. It is about upholding the independence, integrity, and impartiality of the judiciary. The campaign pressure and use of judicial prestige would undermine public confidence in the court. Second, Canon 2 is about performing judicial duties impartially, competently, and diligently. Retaliating against attorneys, favoring supporters, approving false time records, and failing to supervise court staff would all create serious Canon 2 problems. Third, Canon 3. That canon deals with extrajudicial activities. The personal relationship and office conduct facts matter because outside personal conduct cannot interfere with judicial duties or undermine the dignity and integrity of the office. Fourth, Canon 4, and this is probably the most direct fit. Canon 4 governs campaign activity by judges and judicial candidates. The key problem is that campaign activity becomes coercive when it is directed at attorneys and guardians ad litem who appear before the judge, especially when court staff or court resources are pulled into the campaign. If I had to reduce the code analysis to 3 themes, I would say public confidence, impartial administration, and campaign misconduct. So why did I pick this case and why does it matter? It's a good example of how judicial misconduct can become institutional. This was not just a judge being rude from the bench or having a bad judgment in one moment. The findings showed that campaign interests, personal relationships, court staff, and judicial power tied together with her romantic relationship, which tangled her mind, and her alcoholism, it all became tangled together. And the reason that matters is because courts depend heavily on perceived neutrality. Lawyers, litigants, witnesses, and court employees need to believe that access to justice does not depend on personal loyalty to the judge, campaign support, or who is favored inside the courthouse. So the broader lesson is that judicial ethics rules are not just about making judges behave politely, they are about protecting the institutional legitimacy of the court system. In this case, removal made sense because the problem was not isolated. It was a pattern that affected the administration and the appearance of justice.